Copy. There's a couple officers who
Yeah,
had
yeah.
to take
It'll be on YouTube.
exams during the hour,
Yeah.
and they really wanted to see it. So.
Yeah, if sent over here on camera.
Awesome. All right, howdy everybody.
Howdy.
Howdy.
I know everyone is still in line, so please just keep going, but I want to go ahead and get it started since Professor Holland does have his common law class in here. We don't want to run over time again. He's graciously agreed to participate and let us use his room. So I'm going to go ahead and get started. Thank you guys all for showing up. We're very excited. This could not be better timing with the SCOTUS opinion just now dropping. Definitely one of the biggest election law cases, at least of the decade, if not our lifetime. So I'm very excited to hear what our panelists are going to bring to the table on this topic. Professor Holland and Professor Penrose are no strangers to y'all. They are beloved common law professors among many other topics. They need no introduction, but it is my privilege to introduce our guest today, Professor Josh Blackman. Professor Josh Blackman is a national thought leader on constitutional law in the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials, and he has testified before Congress and advises federal and state lawmakers. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law in Houston, and he holds the Centennial Chair of Constitutional Law. Professor Blackman is also an adjunct scholar at the Cato Institute and has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Professor Blackman has written more than 6 law review articles that have been cited nearly 1,000 times. Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Professor Blackman is the president of the Harlan Institute and blogs at the Volokh Conspiracy. I know many of you are familiar with him for his very well-known law review articles on this topic, and we are very excited and privileged to have him here with us today. I'm going to let Professor Penrose kind of take the lead in organizing it. Both panelists are going to have about 10 minutes to give opening remarks on the case, and then they'll answer a series of questions following that. We are going to save time at the end, so be thinking of your questions throughout the event. We'd love for you to ask them at the end. So, Professor Penrose, I'm going to kick it off to you unless y'all have agreed to something different at the beginning.
No, I think that's fine. So I have a question for you in this room. This is, as Sarah just mentioned, and I think this is a really great event to be having. I think FedTalk puts on really good, timely events that enable us to have important conversations as law students and lawyers. So how many of you have read the opinion we're talking about today? Hands up.
That's a good number.
It's a good number. Okay, so the rest of you are hoping that our panelists will educate you on this. I'm going to encourage you as lawyers, it's always important to read the case. I had friends texting me, as you can imagine, the morning that came out. Some said 9-0, some said it looks like we had a dissent. My response to them was uniform. Have you read the case? Because you need to be reading this primary source. The advantage you have today is 2 experts. They're going to talk to you about what they think the case means, what they think the case says, and then we're going to leave some time for those of you in the room to ask questions. I will then pass it off to you. Do you guys care who goes first?
I think Josh is.
Josh, Professor Blackman, if you will go first.
Sure. All right. Thank you so much. It's a pleasure to be back here at A&M. I always like coming here. It's such a warm host. So when I went to law school, I studied the 14th Amendment, right? And you studied the Section 1, right? There's the Due Process Clause, there's equal protection, maybe privileges or immunities. And maybe you studied Section 5, that is Congress's power to enforce Section 1. But there's a gap between them, right? There's Section 2, there's Section 3, and there's Section 4, right? No one in law school for the last year or 2 studied Section 3, but now it's at the center of constitutional law. So here's the text. It's sort of kind of jumbled together, but I want to sort of break it up into different components. Section 3 of the 14th Amendment does a lot of things. At a basic level, it disqualifies certain people who did certain things from holding certain positions. We all agree on that much, right? So who does it apply to? It applies to a person who has taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or an executive, or judicial officer, to support the Constitution. That's what it applies to. Okay. So if you are a private citizen, you don't hold any government office, congratulations, Section 3 says nothing all that. You can be insurrection and not worry about anything. Okay. What does the provision do? If one of these people took one of these oaths, engages in insurrection, or rebellion against the United States. Okay? If you do that, there are consequences. What are the consequences? You cannot hold an office under the United States. You cannot be a senator. You cannot be a representative. Can't be a presidential elector or a vice president. But fear not, Congress has the power to relieve that disability by a 2/3 vote. All right. So these are the four sort of components of Section 3. So there were four sort of Trump questions in this case. First, can Colorado Supreme Court disqualify Trump using its election laws? That's question 1. Question 2, did Trump's oath subject him to Section 3? Third question, did Trump actually engage in insurrection? And 4, is Trump disqualified from the presidency? We can see these 4 questions perhaps a little bit differently in the language of the law. So first off, does Section 3 require federal enforcement legislation? That's the first question. The second, Trump took only one oath, never held a government position. Was his oath as an officer of the United States? That's question 2. Question 3 is, were the events of J6 an insurrection? And so did Trump engage in them? Question 4, is the presidency one of these offices under the United States that extends disqualification? So my colleague and I, Seth Barrett-Tillman, submitted amicus briefs on questions number 1, question number 2, and question number 4. We really have not taken a position whether Trump engaged in insurrection. I'm sorry, whether it was an insurrection on January 6th. We just haven't really touched that issue. As this case went to the Supreme Court, there were a lot of different ways the court could resolve it. The court chose virtually none of those approaches that the parties argued, and instead the court sort of cobbled together what I call a blue plate special. And John Roberts is very good at these. He sort of just whips things together, he makes it sound good, and puts it out. Now, that may sound very critical, but I want to just walk through this. If you read the decision of the court, the first thing you'll notice, as Professor Penrose says, is the first sentence says per curiam, right? What does per curiam mean? It means Latin by the court. No one actually put their name to this, right? No one actually signed it. It's just by the court. And what's the basis of the court's opinion? In a sentence, the court says that Colorado cannot use its state laws to enforce Section 3 against federal office holders and candidates. Not just office holders, but also candidates, because Trump is not an officer, he's a candidate for office. Did the court actually say that only Congress can enforce Section 3? Not quite. Did the court say that the states cannot enforce any federal law against presidential candidates? For example, I don't think 35 years old and so on. No, they didn't say that either. Instead, what was motivating this decision was a fear of having what they might call a patchwork quilt. That is, in different states, there might be different rules about who is in the presidential ballot. And there are some cases, one called Anderson versus Celebrezzi, which says that uniformity is important when you're having a ballot. There's another case which we have studied called U.S. term limits v. Thornton. Here, Arkansas tried to impose term limits on members of Congress. And the court said, you can't do that. Term limits are set by the Constitution, and the states lack the power to add new limits. So what the court did, they kind of just cobbled a lot of things together. They took this Anderson line of cases, they took term limits v. Thornton together, and they sort of said there's a federalism principle that the states cannot enforce Section 3 against federal candidates in the absence of federal legislation. The court didn't actually squarely answer the question of whether Section 3 requires federal legislation in all regards. They just didn't say that. Okay. So the majority was joined in whole by 5 members of the court: Chief Justice Roberts, Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, and for the most part, Justice Barrett. I'll get to Justice Barrett in a minute. But the majority clearly said, we're going to resolve this case So the upshot is the Colorado Supreme Court decision was reversed. Everyone agrees on that much. But then the court said a little bit more. In another part of the opinion of the court, they said, we are not aware of any legislation that exists now which would allow Section 3 to be used as a disqualified candidate. They said, we're not aware of any such legislation. Now, there is a statute in the books that maybe you're familiar with. It's called the Electoral Count Reform Act, ECRA. Electoral Count Reform Act was passed nearly a year ago. And it says if a vote is, quote, not regularly given to the presidency, it can be objected at the joint session of Congress. Some people argue that if Trump wins the election, that Congress on January 6th can actually toss his votes out by saying these votes are not given regularly because you're disqualified. But the court says, we're not aware of any statute that allows them to do this, meaning the ECRA is not such an enforced legislation. The court makes this point even more bluntly. They say, any legislation to implement Section 3 must satisfy the test from City of Bernie against Flores, which I'm sure you learned about in common law, which says that there's a means-ends balancing. There must be congruence and proportionality between what Congress is doing and the remedy they're trying to achieve. As I read the court's analysis of Bernie, the ECRA will not cut it. Why? The law doesn't even mention Section 3. It's a general law about counting ballots. There's nothing about insurrection. I don't think this is tailored enough to meet the majority's analysis. Now, this got probably only 5 votes, not 6, but all you need is 5. You don't need 6 to win a case in the Supreme Court. Okay. So as I read the majority, they're saying, leave us alone. If Trump wins the election, he can be inaugurated. Right? We'll get into inauguration. I'll get to what happens after inauguration. It'll be later in the presentation. All right. Now we're at Justice Barrett. I don't quite know what to make of her separate writing. It's short. It's only a page. Whenever you write something, the first question you ask yourself is, do I actually have to write this? Right? Is this something good for me to put my name to? Or maybe I should just write it and stick it in a drawer and throw it away. This is a drawer opinion, right? This is one that you get your end, you guys, all right, that's nice, I'll throw it away. I just don't see what she accomplished by writing it. She did 2 things. First, she said, I agree with the court that we can't have this patchwork quilt, right? Okay, fine. But then she said, the majority should not have gone ahead and answered the question of whether how Congress can implement this. Now, in fair, I'll give John Roberts a partial defense, because I think he wrote this opinion. I think in Roberts' mind, in order to explain why Colorado can't do this, Roberts had to explain why Congress can do it, right? To show this is how Congress has to do it, demonstrates why Colorado can't do it. So I don't actually fault Roberts too much, at least here, for writing what he did. But Barrett took a step of that. Fine. That was paragraph number 1. But in paragraph number 2, Justice Barrett turned her attention to the other 3 members of the court, Justices Sotomayor, Kagan, and Jackson. And they wrote a several-page concurrence. I'll come back to Barrett. The Sotomayor, Jackson, Kagan concurrence said, we agree with the majority that you can't have this patchwork quilt, you have to have a uniform standard. But they were not willing to endorse the position that you must have a congruent proportional requirement. Don't reach this, just decide the cases in front of us. The Sotomayor opinion, by the way, I keep saying all 3 names, but all 3 of them signed it. It wasn't like just one wrote, they all 3 signed it. The Sotomayor, Kagan, Jackson opinion also sort of fall to the majority for sort of reaching out and deciding this issue. Right? In other words, it might be 9-0 on paper, Professor Penrose's point, but it sort of broke down a little bit once you get into the weeds. Now, how did Justice Barrett respond to the Sotomayor, Jackson, Kagan concurrence? She said, don't be so strident. Strident, choice words, right? Let's turn down the temperature and let's celebrate that this opinion is unanimous. Well, Justice Barrett, it's not unanimous because you fractured off. So it's a very, again, I don't get why she did this. It's her way of saying, look at us, we're not partisan hacks. We're not partisan hacks, look at us. But in doing so, you demonstrate the exact opposite we're trying to demonstrate. It just seems a lapse of judgment. Sometimes less is more. I think there's been less is much more. Nothing was gained by this concurrence. All right, so in my remaining moments, I've lost track of time. I want to talk a bit about what happens next. I think Trump is clear through January 6th and probably through the inauguration. I don't think any other states will try and DQ him. I think that option's out. I don't think that even if there are Democratic majorities in Congress on January 6th, they'll try to knock him out because the court basically said your existing legislation is not enough. Now, Congress is not bound by the Supreme Court, and please, I'm a departmentalist. If the Dems in Congress said, we think the Supreme Court's wrong, I would actually celebrate saying, good, go for you. You Jackson them, right? You stick it to the court, but they're not going to do that. They're not going to do it. So I think Trump will be certified the winner, assuming he wins the election. Polls are whatever they are. Assuming he wins the election, he'll be certified. And John Roberts will give him his oath on January 20th at noon. So help me God. Okay. Now the fun starts. Once Trump gets into office, he's going to do stuff. He's going to do a lot of stuff. It's going to be wild, right? He's going to fire people. Remember the case of Humphrey's executor in con law, where Roosevelt fired the commissioner of the FCC? And then he sued, saying, I have protections for my position. Well, if Trump fires someone, maybe a U.S. attorney, someone will say, wait a minute, you can't fire me. You're not the real president. You're an insurrectionist. You can't hold this office. And at that point, the Section 3 issue is raised directly. I want to make this point very clear. What the majority opinion said is that if you want to go into court and seek relief, affirmative relief, that is removing Trump from the ballot, you need a statute, a federal statute. I think that's right. We all know about Section 1983. When you want to sue the government, you need a statute. But if an insurrectionist removes you from office and you want to challenge that removal because the person's not really holding the office, you can raise Section 3 of defense. You can always raise a constitutional defense without a statute. You need a statute. So the very posture of this case is limited to seeking affirmative relief. Now, the Kagan, Sotomayor, Jackson thing, he said, they referenced, they said, what if a person is removed by an insurrectionist? The majority said nothing about that at all. Right? The majority didn't say that. So I think actually what will end up happening is someone will be fired by Trump, or Trump will issue some executive order, or Trump will take some action against someone, whatever it happens to be, and there'll be a litigation over it. And some will say, this president is a fraud. He is not validly in office. In fact, I don't know, Nikki Haley's the is really the president. Take your pick over this, right? Someone else is the president, ain't Trump. At that point, what does the court do? This is where sort of gets fun. The court could go ahead and come back to our issue and say, aha, Blackmun and Tillman are right. The president's on office in the United States, so sections doesn't apply to Trump. Maybe it happens, maybe it doesn't, who knows, right? But I think more likely, of course, the court says, well, there's this political question doctrine. George Bacon's car, right? Zivotofsky say, well, political question. Congress certified him as the winner. That's good enough for us. So you see the rub, right? The court said, this is a decision for Congress to fix. Congress didn't do a damn thing about it. Suckers, it's your problem now. 4 more years. So I think this was a kerfuffle in a teapot, if you will. It occupied much of my life the last 6 months. I spent more than I care to count. But the upshot of all this, is nothing. We left with this litigation leading almost nowhere. I think Trump, if he wins, I don't know what happened in the election. I don't have a crystal ball. Will serve us 4 years, and this will just be a footnote in a casebook where, and you remember, oh, remember Blackmun, I was talking about this, and that's all you remember about this. All right. Thank you so much, and I will come for your questions later. Good. Oh, thank you.
So Professor Blackmun's done a good job of explaining the decision. I'm actually going to come at this from a different angle. I'm going to begin at a point that I imagine most of you won't expect, but if you could indulge me for 2 minutes, I would appreciate it. I'm going to start with a little bit of philosophical framing. So I'm going to turn to our hosts. One thing that I admire most about the Federalist Society is that it professes as one of its guiding principles that it, quote, places a premium on the rule of law. That is one of the guiding principles of this organization. And in my view, when we fight over originalism and interpretation and construction, what we're really doing is we're engaging in a debate about the rule of law. And the only problem with that is that the rule of law is itself a contested term. Okay? So let me give you one example. There's a philosopher, Joseph Raz, who has said that many legal theorists, as well as politicians and social commentators, have made promiscuous use of the term rule of law. For Raz, the rule of law is this narrow and formalistic thing, requires little more than consistency and that you do not exercise arbitrary power. But on the other end of the spectrum of the rule of law, which I hope as a core tenet of the Federalist Society, you can imagine the importance of, at the other end of that spectrum are conceptions of the rule of law that are imbued with morality and ethics and value judgments. But at the very least, having said that, set up that difference, at the very least, the rule of law requires those who govern, especially the courts, to value consistency in their approach, even if we disagree with it. That is the heart, the unshakable minimalist view of the rule of law. At this Supreme Court, despite its sterling Federalist Society credentials, has become completely unmoored from even the narrowest conception of the rule of law. This court runs from its responsibility to uphold the rule of law because it knows that it's unmoored from its most basic tenets. It's afraid to take a stand that has any actual real world consequences because it knows that there is no consistency in its judgments. The emperor has no clothes, so it runs and hides. That would be the only consistent trait of this court. And why do I start with that? Because that is exactly what happened in this case. Exactly. It is, the decision is inconsistent. It abandons basic tenets of originalism and instead just wields these buzzwords of originalism wildly as both a sword and a shield, never actually being consistent in the way they actually view originalism, which itself is a contested meaning. But can we pick one, please? And more so, and I sort of heard this in what Josh was saying, was this is an incredibly fearful decision. They are afraid, caring much more about their institutional and their individual status than they do about intellectual honesty and consistency. So that's where I'm coming at this decision from. And I'm going to get into the specifics, and I'm going to try to prove this point. But I wanted to give you that larger frame. This is an example of a cancer in the court, a symptom of a cancer in the court. So what did they do here? They completely ran from textualism. They just ran from it, except where it was helpful to them. And even then, they would put it through just tortured readings. Now, I didn't agree with Professor Blackman's conclusions in his amicus brief, but I give him credit for starting with the text and actually trying to come up with an answer from the text. But if the court had done that, at least I would have had some faith in the outcome that they were putting out there. But instead, they run from it. They run from the text as fast as they can. And even when they do engage the text, they misread it. They come up with tortured understandings of what the clause that allows Congress to overcome the disqualification and the meaning of that. They come up with tortured readings of Section 5 of the 14th Amendment, and they can't get to what the Federalist Society likes to call the construction zone fast enough. We are not interpreting, we are constructing as quickly as possible. So, with that mild intro, let me get to how I see the opinion. First of all, Section 2A. You really need to divide the opinion into one, which is the factual background, 2A and 2B, okay? And on its own, the last section. Let's start with what they didn't decide, okay? In the Colorado case, the Colorado District Court held a proceeding which found 6 findings that are cited in the brief. Among those was that the events of J6 were an insurrection. That is the word that they used. It fits the definition of the statute. And that former President Trump engaged in that insurrection. And that gets addressed nowhere else in the entire opinion, other than to say that Colorado found this. Okay? Now, what they do say is that they're going to take a cert question, it's a very specific cert question. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? Now, what would it take to get him to be excluded? As Josh suggested, it'd have to be an officer, it would have to be an office, he would have had to engage in an insurrection, right? All of that would have to be true. But they don't address any of that. Instead, they say, we don't think Colorado could do this on their own. And that's actually a conclusion I don't disagree with. I don't think Colorado should do this. Is it in the text of the Constitution? No. Period. No. It is not in the text of the Constitution that Colorado cannot do this. It is a statement about the qualifications for office in Section 3 of the 14th Amendment. And just as states enforce the other qualifications for office, there seems little reason to believe that they can't also adjudicate this one. I've heard a couple of great examples of that. For instance, if a state had attempted to exclude Obama on the basis of that he was not born in this country, but was born in Kenya, which was an active concern, the court, I'll fix it. Okay. The court doesn't seem overly worried about that. So what makes Section 3 special? Why is Section 3 suddenly different than the other qualifications? You might argue because it's in the 14th Amendment. But the 14th Amendment isn't merely, it does different things. They didn't amend Article 1 or Article 2. So that's my talk right there.
My drop.
So they didn't amend either of those. They put it in an amendment, the 14th Amendment, but it clearly says you are not qualified. End of story. So the only question is who can enforce it, right? That's the only question. Does the 14th Amendment tell you who? Absolutely not. And some of you might point to the 5th, Section 5 and say, well, Section 5 says Congress shall make a law. That has been found over and over again not to require action by Congress. Most of the 14th Amendment is self-executing. And what Congress, it's generally understood, what Congress can do is to go above and beyond to select the means by which you enforce the provisions of the 14th Amendment. Not that Congress is the only one who can enforce the substance of the 14th Amendment. So they ignore all that text. Then they get to the text that they do like and suddenly announce in section 2B, which is why I think Barrett jumped and why the other three jumped. What this opinion should have said is, because of basic issues of federalism, we admit it's not in the text. We admit that we're trying to just to come to the best conclusion based on text that is a little unclear. Let's be honest, we can't do this because of federalism concerns and the unity of the country, which they sort of say in section 2A. Sorry, 2B, excuse me. It's section 2B. If they had just done that, which I think is what Barrett wanted, we'd all be fine. I would look at that decision and go, yeah, I actually agree with it. I think it could lead to disaster if every state got to pick. As a consequentialist decision, but I'm honest about the consequential nature of what I'm doing. This court is dishonest. It is fearful. It is inconsistent. Did anyone notice who read the opinion how much they embraced the 14th Amendment like it was their long lost brother? And how awesome it was and how it derogated the power of the states and elevated the power of Congress? Where is that language in all the other 14th Amendment cases? It doesn't exist. No, they say, no, 14th Amendment, very close, only applies to former slaves, only applies to African Americans. No, right? Suddenly it's their best friend, and it has grave consequences for the relationship between the states and the feds. And that's why we have to look at Section 5, because Section 5, because if the 14th Amendment is so important, we got to dig down into Section 5, right? And rely on that. And that gives us some textual basis. And then they throw around a few buzzwords, as I say. I can't get into all of it in the time allotted, but a little bit of like originalism, what is the one? Oh God, Griffin's case. The most absurd cite I have ever heard. And did you know, anyone who heard oral arguments, they were hanging on to it for dear life. Justice Chase, writing alone, riding circuit, and then later saying that he disagreed with the opinion he wrote in that case, that they're treating it like it's the like Marbury versus Madison. Okay? This is my point about this court. What we should be worried about in this is that the court abandons the originalism it claims to follow. It abandons textualism when it's convenient. It employs textualism when it can be made to support its points. I have a lot of people in my classes who say, I am an originalist. I have a lot of folks, and I actually have a lot of an admiration for that. You have a methodology, you have a belief, and you are consistent. I don't see any of that in here. The only one that's being consistent right now, to be honest with you, is probably Clarence Thomas, although not in this opinion, and Alito, although not in this opinion. Otherwise, none of them. I don't want to take too much more time, but I did want to address a couple of things from what Josh was saying. I don't agree. There's a couple of points we don't agree on, so I want to just elucidate those so that they can sort of pick up on it. I don't believe that the only thing they were saying was that Congress needs to pass legislation delegating states the power. I think it's quite clear that they say only Congress can do this. So I turned your attention to page 5, where it says Congress's Section 5 power is critical when it comes to Section 3, in a part having nothing to do with the states. And then on page, I think it's 13. On page 13, where it says Section 3 works, the distinctive way that Section 3 works and the fact that Section 5 vests in Congress the power to enforce it. No one else. It doesn't say power to delegate to the states to enforce it. It says power to enforce it, period. Congress is never going to pass that law, ever. What's the end result? What I see as a very unfortunate embrace of a strong executive bordering on a king. And I think that is where this court is losing their way. And they're too afraid to stand up for it. Too anxious to have a 9-0 decision in a case that wasn't 9-0. Too nervous about what people think about them. And I'll leave the rest of it.
I want to try and get some common ground and then try and open it up if we can for the students.
Sure.
I'd love to hear their questions, but you pointed out in the beginning, and I think this is important, this is a per curiam opinion. Bush versus Gore was a per curiam opinion. And usually when the court writes per curiam, they don't have concurring and dissenting opinions. But there are commonalities, would you both agree, kind of a Bush versus Gore and this particular case? Mm-hmm. They're probably one-off decisions with incredibly important legal issues that have national ramifications. Yes?
Yes. Yeah.
Do you, either of you, know a legal scholars that are happy with the decision, not the outcome, but the decision? I hear you're both unhappy with the decision. Is that an accurate reading?
I can defend it.
No, I didn't. But are you happy with it?
You mean with the judgment?
It's
The
not.
no. The outcome. Are we surprised by the outcome?
No.
The cert question was clear. I think the court's overall consideration was when we have national elections and 50 independent sovereigns participating, should we have uniformity to protect all of us? Answer: yes. Yes?
I agree.
You agree?
I think so.
Okay. No, and I'm not trying to be, look, let me just back up. I'm an institutionalist. I love the Supreme Court. If you've had me in class, you know this. I'm struggling that the court's at an all-time low. You're upset. I'm Justice Barrett in this decision. Why did you go too far majority? Because then you allowed the concurring justices to call a presidential candidate or suggest as an insurrectionist, right? I mean, the language is, and I think Justice Barrett is quite right. It's a little strident. Can we come together? That's the point of her opinion. It's who she is, right? I like that. I don't understand the other 8, right? Because would we all agree it's a volatile time in America?
Yeah, can I just real quick comment on your grade? Do I believe that we need consistency in elections? Yes, I do. I believe that, and I go against some of my more conservative colleagues on this. I don't believe the court believes that, except when it serves them. Because there are multiple decisions in which they say, only states can decide these electoral questions, unless, of course, my candidate is about to lose the election, and then in Bush v. Gore, I'll just declare Bush the winner, and then in this case, I'll just declare that Trump can be on the ballot. Neither of those is consistent with their jurisprudence regarding the rest of who controls the ballot. And where they're like, states.
And I do want you to respond to that, because I think that deserves a response.
Right. So the consistency point is a little bit tricky, right? Why is this tricky? Because Section 3 has nothing to do with ballots, right? Section 3 concerns former Confederates who are holding office. And what happened after the 14th Amendment went into effect, right? 14th Amendment goes into effect in 1868. And over the next year or so, there's a lot of disagreement over how we actually go about this. In southern states, military officials removed certain people who were holding state offices who were disqualified by Section 3. Then we have the Chief Justice Chase, who was derided a minute ago. Chief Justice Chase is a pretty good guy. And he issued a decision that settled this issue very quickly. He wrote that federal legislation is indispensable the words he used, to enforce Section 3. And immediately after Chase said that, everyone fell into line. Congress enacts legislation to enforce Section 3. Now, the reason why I hesitate on Meg's question, I think states can enforce Section 3 against their own people, against state officials, that legislation. Texas can impose whatever qualifications they want on Texas officials. And I think that states can impose qualifications on their electors. Giaffalo teaches us that. Right? When you vote for president, you're not actually voting for president, you're voting for the electors. Just be very clear who you're voting for. That's why I paused on her question just slightly. So we speak about uniformity. States have a lot of power over this. But what the states cannot do, and Chief Justice is exactly right, is impose requirements on federal officials, members of Congress, the president, and also elected, appointed office holders, right? So I think the court recognized this. It's true the court only mentioned Chief Justice Chase's opinion in passing. I can talk about Trump's lawyer for an hour why he wouldn't take this argument. It was a mistake. But there's an argument to be made that whether Chase was right or wrong, he settled the issue. You have liquidation, institutions like liquidation. And I think the court recognized this, but they couldn't come to an agreement on a very short time frame of this issue. So they basically cobbled something together as a ticket good for one ride. Which before, back to your question, was a ticket good for one ride. This is a ticket good for one ride. Will not be any common law case book. We'll forget about it tomorrow, and then maybe we'll get an actual decision issued later. That's how I sort of view this case.
Can we all agree that it's great to see a modern case citing both Marbury and McCullough in the same decision?
I agree with that.
Right. So talk about federalism. It reminds us that it's the job of the court to say what the law is. And these cases are difficult. I mean, Professor Blackman started by calling, I forget, what's the slide before the 4 legal questions?
4 Trump questions.
Okay, but these are legal questions. And when I talk to people, conservative, liberal, I'm teaching lawyers, they're legal questions. Please tell your friends these are about the law.
Mm-hmm.
And this may be a one-off, but it may not, right? Professor Blackman, you just said that Section 3 was about the Civil War and resolving that, but it's still a part of our Constitution. So what do we do with its modern application?
You asked the question. I think, to be completely candid, I'll focus now on what was an insurrection. There is no federal statute defining insurrection, the federal insurrection statute. How many people from January 6th have been charged with insurrection? Number is 0. 0. Proud Boys, Oath Keepers charged with seditious conspiracy. To be completely candid, we don't know what insurrection means. It's a political judgment. That's with a lot of factors maybe decide after that. Because with the Civil War, everyone knew what the insurrection was. It was a Civil War. There's not a dispute. Because I think it's so hard for us to even decide what insurrection is, I think at a minimum, Congress should say, here's what insurrection means. Here's a process in which people can be charged with insurrection. We have a statute. Person's actually convicted of insurrection. That's a good basis. But short of that, having a trial judge in Denver, 3,000 miles from the Capitol, decide whether it was an insurrection in J6 strikes me as problematic in a lot of regard. I don't know. So I don't know what the vitality is of Section 3 anymore, unless we have a clear definition of what insurrection is. Unless you know what insurrection is, all the other stuff is, we don't really know.
Is insurrection like pornography? When this and what I mean by that, I will clarify.
Settle down.
If you have not yet taken First Amendment, take it. But in that, one of the times the court says, we can't define it, but we know it when we see it. Would you say it's not?
I think he's totally wrong about insurrection.
Okay.
Insurrection, you can't on one hand tell me that we need Congress to define insurrection and tell me that the courts can define every other term in the Constitution. It's in the Constitution. Is there some reason that Congress and not the courts, which claim as originalists to be able to divine from the language itself the original meaning of the word insurrection as it was post-Reconstruction amendments, why do we need Congress to do that in this case?
To rephrase, a procedure to determine a person engaged in insurrection, right? It's not just what the insurrection is had to decide who actually was a part of it.
Oh,
right?
I agree. That's a court of law that then you determine, you take the definition of insurrection, you look at the facts presented in the case, and you decide whether they engaged in insurrection. Bring that to a court, which is exactly what happened here. It went to a court, and the court decided. And this is where I get frustrated, as you can tell. I feel like it's so convenient to say we don't know what an insurrection is because Congress hasn't told us. Okay, then the immediate aftermath of the Reconstruction Amendments, which is what every originalist tells me will answer all questions about the 14th Amendment, that should tell us. And we don't need Congress to do that. If you want to talk about Congress having procedures, again, where does the Constitution say that? Courts have been using procedures all the time to figure out who was engaged in the thing we have now defined.
Was it an error in the Supreme Court's per curiam opinion not to address insurrection? It was
Well,
it's one of your three legal
Yeah,
questions.
I don't see how they could have given the posture. If this is, it's not quite jurisdictional, but it's kind of jurisdictional. If Colorado can't do this, then don't touch a merits issue. It's almost like a standing or a threshold issue. So I don't think there's any opportunity to do it. There are many other ways the court could decide this case. We didn't talk about my officer stuff, as Justice Kagan lovingly called it. That would be one way. Justices Jackson and Gorsuch were very interested in my theory during the arguments, my theory of theft, and it didn't prevail today. We don't know why. Maybe in 30 years we get to the papers, we'll see it. But in this posture here, there's no reason to discuss insurrection. There's also the issue of what evidence to use. The trial court admitted the January 6th report, which Trump attacked viciously as a partisan document. Was it hearsay, right? I mean, is it clearly erroneous? Is it abuse of discretion? What's the factual standard? There are a lot of reasons why Congress must create a procedure to do this. And I think that's why Chief Justice Chase was correct. This can't be done in this sort of ad hoc fashion.
So what makes that ad hoc versus any other case where they are interpreting and applying a constitutional provision? What does equal protection mean? Congress doesn't have to tell us that. There are some places where they've told us what that means, but there are other places where you just can sue on equal protection. It's a standalone, self-executing thing. Why is this special?
But again, so I want to talk about the self-execution. I'm sorry to go back and forth. The self-execution point is actually very important. You may have learned in common law that the 14th Amendment self-executing. That is only half correct, right? Again, if the government takes some action against you, you can always raise the Constitution as a defense. You don't need a statute. But when you want to seek affirmative relief, you do need a statute. And Congress enacted zero enforcement acts in the wake of the 14th Amendment to actually carry into execution, okay? And those statutes actually provided various procedures by which you can obtain relief. So I think we're maybe arguing over semantics, but the procedures that Congress establishes are important. Should insurrection be decided by a civil procedure or a criminal? Do you get a jury trial, or is it just a preponderance of the evidence? These are important questions when deciding that disqualification. Those stations, Section 3 is kind of unique. Nowhere else in the Constitution is there a way to disqualify people from holding office. You're either born in this country or you weren't, right? Either 35 or you're not. I mean, maybe over birthday or so on, right? But your age is your age. But this is something that's unique. And let me make sort of a broader point. Did you say the slaughterhouse cases in common law?
Most of these people have a take.
Oh, I'm sorry. So in the wake of the 14th Amendment, the court issued a series of decisions that narrowly construed it. The slaughterhouse largely gutted the Privileges and Immunities Clause as a crook shank. The civil rights cases largely gutted Section 5. And why? The 14th Amendment was such a radical change to how our Constitution operated, the judges didn't know what to have to do with it. And I think it reflected a pragmatism that, wait a minute, what are we doing here? And I think sort of Chief Justice Chase made that judgment. It says if we allow Section 3 to be enforced without Congress, it can lead to a lot of bad things. I'll call that pragmatic, but this was a judge making a decision when the 14th Amendment was ratified. I think that reflects its original meaning just as much as other things that were said at the time. I mean that sincerely. So to some extent, maybe the original meaning of the 14th Amendment has a dose of pragmatism. This is how people understood that. We're not really sure how it's going to be enforced, and maybe we should do this in a fashion to avoid the chaos that the majority worried about. And
All right.
I'm okay with that.
I'm gonna open it up to questions. We have a question.
Yeah, so I think that this question kind of couches on your like reverence for Chase's decision in Griffin's case, is that he wasn't acting as Chief Justice when he wrote that opinion.
No.
He was running circuit. And so I guess like, is the internal logic of your position that we should treat all of Justice Berger's opinions when he was on the DC circuit as binding precedent for SCOTUS?
Not at all.
Then how do you defend relying on that as controlling precedent
Oh, I
for the purpose of it.
Sure. So in the wake of Chase's decision, it was cited dozens and dozens of times. The U.S. Supreme Court cited it in the unanimous opinion, right? People in Congress referred to the decision when passing enforcement legislation. There is very good evidence this was seen as an important decision. And you know why the case stopped at the Circuit Court was appealed to the Supreme Court? Ex parte Carnal. The Supreme Court had Congress had stripped the Supreme Court of jurisdiction. There was no appeal to the Supreme Court. You couldn't appeal this case. So, and actually Chase says in his opinion at one point, I actually started to check with my colleagues, they agree with me on another habeas issue. This was the decision that sort of settled the issue for 150 years. So no, a Berger decision from the DC Circuit is lovely. We can read it, it may be well done, might be rare, right? But Chase's decision settled this issue, and I put a lot of stock in that. No one came out and said, wait a minute, Chase is wrong, we need to overrule him. What did Congress do? They passed enforcement legislation, which is consistent with what Chase said.
I will add to that, though, that it's interesting how they use Griffin's case here, because they don't actually cite it as precedent. It's very odd.
Weird, it is weird.
It is. They say what they use Griffin's case for is two things. One, someone will have to ascertain who is covered by it, and then someone will have to figure out what the procedures are.
Weird.
And those are the only two sites to Griffin's case. They don't say, and it should be Congress.
Don't say that, you're right. It's a weird opinion, I'm not gonna defend that part. But I think, I won't, but I think Griffin was lurking in the background, whether they incorporated it or not.
Is there anyone defending the opinion?
I'll defend it.
You just said you're not
That
defending the
part.
opinion.
That part.
So-
I think the decision is basically doing what Chase said without citing Chase. I think they're agreeing with Chase in all regards, and that's why I think it's actually more original as people willing to accept.
Go ahead.
So what do you think the court was trying to do then in giving out this per curiam opinion?
Get 5 votes for Super Tuesday. So I'm sorry. That was not that was a very flippant answer, and I didn't mean to. You asked me a very good question. I want to make sure I answer your question respectfully. I think the court was under very tight time constraints, right? They had to decide this case. Colorado's primary was yesterday, right? So they had to decide it. And usually the court has 8 or 9 months to decide a very big issue. They had a couple weeks. And this was the best they could get out. That would get 5 votes. Maybe Professor Penrose is right. If they had done a little bit less, they'd put 9. But they worried about this coming back in January. So they said, this is what we're going to do. Keep calm, carry on, and let's move on with our lives.
May I follow up on a question? Using that logic, should we as a society expect the Supreme Court to resolve the criminal immunity case with the same deliberate speed? And I want to use a line from Justice again. I don't like concurring opinions.
I know that.
I
She wrote
like
an article on this, by the way.
I like this opinion because she says the court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstance, writers on the court should turn the national temperature down, not up. Do you expect because your first response may have been flippant, but it may have also had a kernel of truth. Will we get a decision on the immunity question in time for there to be a resolution for the voting population?
I think the decision to grant certiorari makes it very hard for that to happen.
Well, it happened here. It happened in Bush versus
No,
Gore.
but I mean, the trial will take 2 to 3 months, just as a matter of just procedure, right? The trial will take 2 to 3 months. If the court decides the case in June and you start the trial, let's say in August, that puts us finishing with the jury in November, maybe afterwards, right? In other words, it might not be feasible to get a decision at the end of June to actually get a verdict, a jury verdict by election day. And look, people vote early, right? Half the people vote in like October. So election day doesn't exist. It's a month, election month, basically. So I don't know by granting cert if it's even possible. Now the court could quickly remand it in May, the week after it's decided. If we actually argued, they can do that. But I think what the court's saying is we're going to not allow this to go forward. The other wrinkle on this is Trump wants the trial in Florida to happen in July to August. Why? You can't try a person twice in 2 different courts. He's hoping that by doing the July case first, it can kick the DC case till after the election. And once he gets into office, he's going to pardon everyone involved in J6, including him. So I think that goes bye-bye.
I think I agree with you 100%.
Yay.
But we're missing the rationale, which is, once again, the Supreme Court is afraid to do its job. It is trying to put this off and hope that the election solves it for them, that it takes all of the pressure off of them. And instead of doing its job like it should, this is just another form of punting on the question.
But Bush versus Gore was decided even more quickly than this case, and this case was decided in days, not months.
This was about 3 weeks. Yeah.
So why would the Supreme Court not elevate an equally important, and again, I'm looking at a legal question to then lend legitimacy to voting decisions. Why would the Supreme Court pause as if this isn't equally important to resolve?
Again, so I mean, this gets into the weeds a bit, but this was a hard opinion to write if you want to do it carefully. Because you might have to agree with Josh and Tillman on the officer issue. You might have to actually say that Chief Justice Chase was correct, even though a lot of people think that Chase was inconsistent with labor doctrine. I don't think he was, but I know that position's out there. You might have to go down the road of whether it was an insurrection. Every road you take has pitfalls. And the court, Court Robert Frost took the road less traveled, the road that doesn't actually lead anywhere, and that sort of ends this case. And Chief Justice Roberts, I know people on the left sometimes like him. I am not a fan of his because his pragmatism always goes first, and it sort of frustrates me because we have to make sense of his decisions. That's what we got. And
I 100% agree with you on that one.
all right, well, we got more agreement than I thought.
This is what's beautiful to realize, that in this building, there is far more agreement among us than there is disagreement, although there's a question that wants to change that perhaps.
I just want some clarity. Everybody seems to be assuming that Trump's going to win again in November. It's equally likely that he loses for the third time again. And
The third time?
yeah, he loses for the third time. And you said there's currently no federal insurrection statute.
There is.
Is there?
It's a criminal insurrection statute, yes.
Okay, that's what I wanted clarity on.
Yes, there is one. He's not been charged with it. No one's been charged with violating it.
Okay, that's wanted clarity because that kind of sorts out my question.
Okay.
Loses again in the third time. He does all this again. We have a repeat, that train wreck. Now do we have the issue of, is he engaged in insurrection under?
Well, these are the hypos I raised. If someone's fired by Trump, the court will decide whether Trump is actually the president to fire him. So if Trump signs an agreement or a treaty or some executive document, people are affected by that. They're standing. James and Morphy Regan is an example. So it'll be litigated. There's no question. If Trump wins, it'll be litigated. I just don't know.
And he did win in 2020. He was the legitimately, he is a legitimate president who won in 2020. I mean, we have to be fair on the facts. Yes, I'm sorry. I would also like to say the president.
But I think, where were you on January 6th? So I mean, I think there's an important point there, which is, I think a Roberts court says political question, we're not getting involved. I honestly think that's where it goes.
That's what I wrote. Yeah, that's what I think.
So once again, and this will be the ending spot, though I encourage you to email, text, and visit with our presenters. There appears to be a lot of agreement among constitutional scholars on the law, but sometimes we disagree on the outer edges.
All right. Thank you all so much.
Couple quick announcements before you leave. For those of you who remember, we do have elections coming up. There was a link that was sent out to you guys to nominate and to run. If you have questions, there is a Zoom meeting tonight at 7. You can jump on and we'll talk to you about the election process. Let me know if you need the link. And also, just remember we have a happy hour on Thursday from 7 to 9 at Nickel City. And we'd love to see you guys there. Thanks for coming.